27th Friday group meeting. Speaker is Mr. Raghavacharyulu. He came all the way from Hyderabad, particularly this thing. Today's topic is analysis on Mineral Area Development Authority versus Steel Authority of India, and another is a Constitution Bench judgment, recent Constitution Bench judgment. He is a very prominent lawyer in this area. He is doing extremely well, and I request, Rahul will read few things about Raghavacharyulu. Rahul, please,
Sir, first of all, thanks for coming from Hyderabad for this lecture, sir, and thanks Sheshu sir for giving me this opportunity to read the CV of sir. Sir name is K.Raghavacharyulu. Sir was born on 9th of February 1962. Sir enrolled on 7th of June 1985 with the State Bar Council of Andhra Pradesh, Hyderabad. Sir is a member of various prestigious bar associations including Supreme Court Bar Association, Telangana High Court Bar Association, Orissa High Court Bar Association, Uttarakhand High Court Bar Association. Sir has been practicing since 1985, since 38 years, since 1990 appearing before all high courts in the country as well as before the Honorable Supreme Court of India. Sir expertise in various branches of law, which includes the constitutional law, criminal laws, mining laws, forest and environment laws, patent and trademarks, company law, arbitration, other civil laws. Sir has represented central government and various state governments before the Honorable Supreme Court and various high court across the country. Sir has been the special counsel for appearing in the Supreme Court of India representing the government of Manipur in Manipur riots cases. Sir has been the special counsel for conducting central government litigation before the Supreme Court, special public prosecutor of the Delhi Special Police Establishment, Central Bureau of Investigation and Delhi High Court at New Delhi. Sir has been the special public prosecutor for Sardar Chit Fund Scam Roosevelt and its related cases before the High Court of Calcutta, all other high courts and Honorable Supreme Court of India on behalf of the CBI. Sir is an All India Standing Counsel for National Mineral Development Corporation Limited (NDMC) at Navrata Public Sector Undertaking and appearing conducted their cases throughout the country. Sir has also been appointed as the Advocate General for the state of Manipur on 18th of April 2017 but has not joined the office due to some high threats perception. And sir is being the counsel for the Food Corporation of India also. There are 18 reported cases of sir in which sir is argued before the Honorable Supreme Court of India. There are 8 cases which has been published in the before the generals, in which sir has been argued as the special public prosecutor for the Delhi High Court for CBI, and sir has appeared as a special public prosecutor of before the Supreme Court for various high courts including Orissa High Court, Madras High Court, Calcutta, and there is a publishing also. Sir has published an article, Indian Legal Section 102 CRPC, the powers of police officers, the procedure, compliance, non-compliance and remedy to be aggrieved. Thank you, sir, and also can start the lecture.
You can initiate.
Good afternoon to all my brother and sister advocates. I am thankful to Mr. G.Seshagiri and his team for giving me the opportunity to say a few words about the landmark judgment of 9-member judgment. And after an assiduous reading of the judgment, coupled with the experience which I have since 33 years in Supreme Court, I am privy to the judgment start from T.N. Godavarman, where the first time the Supreme Court has come down heavily on the illegal tree cutting in Godavarman's case. And then I was also there in the Samaj Parivartan where the illegal mining was there. So I am privy to all these informations and how the law developed on Mines Minerals Development Act. And I am also privy to the development of law on the Forest Conservation Act, Environment Protection Act, etc., all the parliament legislations. With that experience in a humble way, I would like to present myself, my understanding about the judgment, which is absolutely my personal view, and I declare I know of no better than the learned judges who delivered the judgment. I have one proposition which I believe personally. It is judicious to know the past to appreciate the present. To appreciate the present, one should have a judicious approach or acquaintance with what was the past. Similarly, it is the jurisprudence to know the present and to decide the future. It is only the jurisprudence to know the present to decide the future. Unless you mix the jurisprudence to the present facts, you will not be able to visualize what is good for the future and how it is to be implemented. So jurisprudence plays major role, and jurisprudence is nothing but stitching of the various acts, interplays, and how it is going to have a balanced view on combined reading of the whole gamut of the legislative field. So keeping these things in view, now the latest judgment of the 9-member bench, where 8 members on one side and 1 member and dissent on the other side, it is a very important judgment, landmark judgment. It has a lot of consequences which this country has to face. In these judgments, basically, the 5 to 7 year decades judgments are upset, and a new dimension is given, and new approach is given. So therefore, we are here to discuss how it is going to affect, whether this judgment, whatever is delivered, is in consonance with the previous laws that are already declared by the Supreme Court, or whether it is follows with the constitutional scheme and constitutional philosophy. That is to be seen. Before going into the various aspects dealt in the judgment, for the benefit of all my brothers and sisters, I would like to submit humbly. First, one should know what is called mineral. Mineral is a general word, and there are people who might not have come across how the mineral look like, and there are people who may not be aware what is its role in these economic conditions of this country. Minerals basically formed because of the geological process. To put the geological process in the smallest format, under the earth we have huge rocks. These rocks gets heated up. Once they get heated up more than 1000 degrees Celsius, these rocks will get converted into burning rocks. They are called as magma. These burning rocks, as long as under the earth, you will not feel heat of it. Once these burning rocks, which are called as magma, erupts and surfaces on the surface, they become as lava. That hot liquid becomes as lava. Once it is erupted on the earth and came to the surface, this lava, through volcanic action and reaction, gets carried on the earth, and then it becomes cool because of the atmospheric conditions. Once it becomes cool, it forms as mineral, mostly in the crystallized form and hard form. That is how the minerals are processed, minerals are produced. So minerals are not a produce of land, minerals are a produce of earth. And earth, reaction with the magma and lava travelled through volcano on the surface of the earth, which we call it as land. They form as minerals. And it depends on what kind of eruption took place and what kind of mineral was formed. It is not that these volcanic reactions and magma and lava are formed only on the earth. It can be under the sea as well. That is how we have minerals under the sea, we have minerals on the land, we have minerals like hills, we have minerals under the soil. So these minerals are everywhere, in different parts, in different shapes. And such kind of minerals are required to be regulated. All of us know India is not one country, it is a combination of 584 princely states. Kindly bear with this. We have different linguistic problems, different yardsticks, Some areas are thick in forest, some areas there is no forest, some areas are rich in minerals, some areas rich in particular minerals, some areas have no minerals. So this union of 584 princely states, minus 2 states initially objected to by Nizam the Great and the Kashmir Raja Hai Singh. Ultimately they also surrendered. And then the parliament has decided we should have a constitution, and more particularly a written constitution, to balance the things which are spread across the country. These 584 princely states, they have their own laws prior to this union. They have their own systems, they have their own procedures, they have their own socio-economic political conditions before the union is made. Once the union is made, how to balance these things? Then the Constituent Assembly was constituted. It was decided to have a written constitution, and Constituent Assembly discussed so many issues, and finally they have given a masterpiece called Indian Constitution. Indian Constitution is like Yadbhavam Tadbhavati. Yadbhavam Tadbhavati means the way in which you look at it, you will feel it. You look at it as it is a federal constitution, it looks like federal. If you look at it as central, it looks like central. You look like it's a quasi-federal, it looks like quasi-federal. So it is somebody's feeling how they wanted to look at it. So it is a mixture of all the things, and it's a unique masterpiece, giving so many balances. Such constitution is on the one side, and it also declares by way of preamble, what exactly the people of India desire. Socio-economic, political, all of us know. Preamble, they declared it. What exactly the Indian people need it. Preamble is an index before going to the next page. And after the preamble, we have part 3, the fundamental rights, which are heart to the constitution. And then followed by part 4, directive principles of, which deals with the present subject. In the directive principles only it is written that equal distribution of the natural non-renewable energies for the common good across the country. Article 39 A, B, C. And then part 11, which deals with the distribution of powers between the state and central. So a combined reading of preamble, part 3, part 4 and part 11 makes it abundantly clear that the constitution makers wanted a strong center to be there. Ambedkar on 25th of November 1949 in his Constituent Assembly speeches, he gave the reason why this country should have a strong center. He also says India with great difficulty we got the freedom because of difference of opinion among the Indian kings. One king facilitated other Britishers to enter, another king facilitated Mughals to enter, and India's freedom was invaded because of the outside forces, because of no unity among the kings. So Ambedkar felt almost turned to tears in this Constitution Assembly once he read. He refers Indian as a she shall not lose her independence again. We need a golden thread which should consider and which should meet the end of all people for the common good as a country as a whole. Kindly appreciate, as a country as a whole. This issue is required to be looked at country as a whole. Don't look at it as a mineral, don't look at it as a forest, don't look at it as a constitution, don't look at it as any other angle. First, the paramount consideration is country as a whole. When country as a whole is to be there and services are to be reached to the end to all with equitable distribution of natural resources, Ambedkar categorically says we need a strong union. We need a center with more powers. While it looks like federal structure, it does not mean that states will have all independence. Some of us are maybe aware of that in the recent past also. Some state government tried to give away 10,000 acres of land to the Singapore government with all sovereign powers. The High Court of Telangana has to struck down that. So this kind of things could have happened had there been more legislative powers, parliamentary legislations. giving power to the Parliament to continue to bind this unity as one unit, because we have a unity in diversity. Those are the things to be protected. While those things are there, now the present judgment, bringing him home to the point, says that the land inclusive of mineral bearing lands. So the state government, being given the power under list 2, entry 49, under the caption of land and buildings, has the legislative power to legislate on mineral bearing lands. Long and short, that's what they mean. Despite there is an entry 18 in list 2, particularly dealing with land in and above. Despite the fact that there is entry 50, which deals with mineral rights, tax on mineral rights. The majority view is the tax on mineral rights is different. The phrase land and buildings is capable of taking in its fold the mineral bearing lands within the caption of lands. Though land and buildings are conjuncted by an expression called and, though they are inseparable. The opinion of the majority view is that the land is used in entry 49(2) is capable of taking it to engulf itself to the statutory power to make legislations by the state legislative assemblies. Now, what is the meaning of land? Land, according to me, is too general a word, and it is generic in nature. Land is always to be understood subject to the context in which it was used. The simple meaning of land is nothing but the face of an earth. Earth is below and the face of an earth is land. The face of an earth is the land. The minerals are produce of earth. Such being the case, the expression land and buildings used in entry 49(2) whether confers power upon the state legislatures to make legislations relating to mineral bearing lands. You take blood for example purpose. Blood is a word, general word. All of us know blood, how many groups it has. And there are some people who are A positive, B positive, O positive, so many things. Similarly, land also has different classifications. You have government land, you have private lands, you have mineralized lands, you have non-mineralized lands, you have hillocks, and you have hillocks again, mineralized hillocks, you have again hillocks with rocks. So many permutations, combinations and classifications are there in the land itself. So just because an expression is used on lands, is it in consonance with the constitutional philosophy and constitutional scheme conferring power upon the state legislatures to make laws relating to the mineral bearing lands as well? That is the question for today. For that purpose, I have made little study, and the study reveals, coupled with the experience whatever I have at my command, that the question to be addressed first is, what was the constitutional philosophy? Though the heading was given in the judgment, the relevant judgments dealing with constitutional philosophy perhaps might not have been brought to the kind notice of the Honorable Bench. There are landmark judgments dealing with constitutional philosophy are not forming part of the judgment. Because I was not a party who has argued this case, I am not aware what kind of judgments are cited, but ultimately we are only known by the reported judgment. As can be seen from the reported judgment, the landmark judgments, more particularly the judgments of constitutional bench judgments, which came to this court as a reference from the President of India, were also not cited. There are judgments in the natural resources, which has come to this court as a reference by the then President of India, Pratibha Patil, asking this court to explain certain things. That judgment deals with the equitable distribution or equal distribution of natural resources. Similarly, there are various other judgments. In fact, my friends, if they are interested, I can circulate it, the note I have prepared it, which are not really considered by the court, perhaps might not have been cited. And second aspect is, one has to see the context. The test to the text, TEST test, to the text is always the context in which that word was used. All of us are aware English is not our mother tongue. Some expressions were there. Some English expressions were used. Each expression, they are general in nature, has different meanings depending on the situations. In Reserve Bank of India versus Peerless Insurance Company, Justice Chinnappa Reddy made a beautiful paragraph, paragraph 22, I will be giving the judgment. He says the test to the text is always the context. One has to see, wearing the glasses of the legislators, in what context and with what objective a particular enactment is passed. And what he says is, every word has a place and it is at its place. It is only the combined reading of the entire enactment, section by section, clause by clause, word by word, we will come to know by giving the context in which it is used. Even if you take the definitions of various parliamentary legislations, including the Indian Forest Act, while defining forest produce, they say that subject to the context. Forest produce is this. Various enactments you come across and see the word prefix, subject to the context, this is the definition. In what context the land and buildings was used is the question. The land and buildings was used in the context in list 2, suffixed by hearths and windows. That was omitted subsequently. It means there is a land, there is a building, there is a firefighting system, there are windows. So they were all omitted back to portions. That omission is used now giving emphasis on lands, which is incorrect. That omission fortifies the view that it is meant for a different purpose. Land and buildings means the house site. Land has got different meanings. Land, area, site. There are so many expressions to describe the extent of the lands. So land and buildings always relatable to a site, site specific. If when you come to the mining leases, you will not find a single word called LA&D, land, in the entire MMDR Act. It is very unfortunate that this was not brought to the notice of the Honorable Court. In the entire MMDR Act, you read the expression called LA&D, land, you will not find. MMDR Act only says area. Area leased out, area applied for, area granted, area clearance, all those things they speak only AREA, area, no word called land. The legislators are more intelligent than us. They know why they have not used the word called land while in drafting 1956 this act is, the minute they say land, entry 18 will apply. They know that entry 18 is there by the time of 1956 when they drafted this 1957 act. Constitution has already come into force. Schedules are already available. Distribution of powers is already available. To make this 1957 act in consonance with the parliamentary legislation called entry 54 list 1, they have not used the word called land. This area was missing in the judgment. So, if you are constructing a house, you call it as house site. It does not mean that it is not land, it is also land. If you are constructing a building, it is a building site. If you are constructing a complex, it is a complex site. If you are dealing with agriculture lands, it is an acres of agriculture lands. So that is also land only. And if you are dealing with mineral concessions, the word carefully used is area. Mineral mining lease area. The reason being, suppose the mineral is in the government land. No, government neither insists nor anybody pays any surface rights rent to the government. What they pay is the royalty. That is the extraction of the minerals. So the area is pertaining to not the surface rights, the rights relating under the subsoil. Even if it is a hill deposit, they will use only area. They don't use any say, land or any other expression. Though in the schedule of Form K, which is dealt with, says large tracts of land, but the right is given only for extraction of minerals. Right now, right on the land. After the lease period is over, there is R&R procedure, reclamation of land, and it will go back to the government. No lease is for eternal purposes. It is only for 20 years initially, 30 years, 10 years renewal. Now it is made as 50 years. So the land always goes back to the government or private, whatever it is. That is why there is using the expression called land into MMDR Act, according to me, is an error apparent on the judgment. Because the Act doesn't deal with land. The Act deals with only minerals and mineral rights and in an area. Similarly, when once list 1, entry 54, clearly says, once union decides to have in its control the regulation and development of minerals in its control, and using that entry, MMDR Act is passed with section 2 declaration, declaring, the union declares, it takes into fold of all the regulation and development of mines and minerals into its fold and passes an enactment. This entry 54 read with entry 23 of list 2 makes it very clear. Entry 23 says mineral regulation and development of minerals subject to list 1, subject to the limitations imposed in the list 1. When you come to the expression limitations, limitations are, some are apparent, some are not apparent, some are to be understood. Understood basing on the scheme of the constitution, they are called implied limitations. Even if you see the planetary positions, you will not find Neptune and Pluto. It's not that they are not there, they are there. They are not visible to you. They are called as Chayagrahas. They are there. These limitations are implied limitations which might not be written, but one has to understand. So entry 23 of list 2 is always subject to entry 54 of list 1. That is what the law for the past 7 decades in this country. All judgments speak about that only. Now, such being the case, there are independent entries relating to the mineral rights regulation and development. Development of mineral means what? Development of minerals means it is not that there is a hill and you develop it by adding some more mineral on it. No. Development of minerals is better conservation of minerals is a development. How do you better conserve the minerals? Being the liberal laws, being the laws that the trade needs, these are trade specific minerals. This is a subject which is totally special subject relating to the industry, and it has a scientific angle. When similar subject came before Justice Lahoti, when Mr. Mukul Rohatgi was the Additional Solicitor General, I was the briefing counsel, it's the reported judgment. This court called the experts of the country with red pass, which we gave, demonstrated before this court how this mineral processing takes place by seeing that that judgment has come in 2004 SC Supreme Court page 481 or something, 481. So this is a scientific subject. It has its own ramifications across the country, and it is going to affect the socio-economic conditions of the country. Because start from Chanakya days, minerals are the source of the prosperity. It is the minerals they deal with the prosperity of the country. For various reasons, India was divided into 24 states, 28 states, now 29 states. It is not that these states were there prior to the formation of the India. India is not united India. It is a union of India. It is one unity of India. It is not that total completely different people are stitched there. So keeping these things in view, the constitution was drafted in such a manner, wherever the natural resources are there, wherever key areas are there, wherever the sovereignty and integrity of the country is involved, they reserved the areas to list 1. At the same time, giving autonomous status so far as the land and other issues are concerned to the states. They maintained a balance between them. If you read the Constituent Assembly debates, it was debated so well before these entries are passed. and there were some members who says each state should be given complete freedom on all subjects. Why list 1 and list 2? One speaker says, let us make list 2 as list 1 and list 1 as list 2. So like this, several discussions took place. Ultimately, it was decided to continue to have this country as unity in one unit and to protect its sovereignty, to ensure that it doesn't lose its freedom again. They decided finally with one word called strong center. That is the word you will find it. It is not that keeping in your one political scenario I am saying. It is not today's political scenario, it is not yesterday's political scenario, it is not going to be tomorrow's political scenario. But end of the day, this country to protect its freedom, independence, need a strong center to protect it. Keeping those things, how the center will become strong? Unless it has some control over the states, it cannot become strong. What kind of control it should have? It is not that every control. Every state is respected. That is how the constitutional courts in this country functions. Every high court is an independent high court. At the same time, Honorable Supreme Court is also there. And it used to be said earlier orders, if you look at it, we request the High Court to expedite the matter. That is how the learned judges used to pass the orders. They never used to say that dispose of the matter in 3 months. We request the High Court to do it. So while protecting the autonomous status of each High Court, the Honorable Supreme Court functions as an apex court here. Similarly, states also have their own autonomous positions on certain areas. In some areas, keeping in view of the socio-economic conditions, more particularly Part 4 of the Constitution of India. Part 4 of the Constitution of India, what it says? 39A BC. Says certain principles of policy to be followed by the state. It is part of directive principles of state policy. The state shall in particular direct its policy towards securing A. That the citizens of men, women equally have the right to adequate means of livelihood. B. That the ownership and control of material resources of the community are so distributed so as best to subserve the common good. The operation of the economic systems does not result in concentration of wealth and means and production of the common to the determined. So equal distribution is part of this directive principles. If you read preamble, part 3, part 4 and part 11, it makes it clear that the Constitution decided that we should have a strong center. Strong center means the Parliament should have the powers to pass laws relating to the common good and for the benefit of all. MMDR Act was passed under 54 list 1, and there is a residuary power also to the Parliament. Now coming to the present judgment, most of us must have read it. I have dealt with as in chapter 14 as critical analysis of the judgment. According to me, the crucial and the entire part 4 of the Constitution of India is not considered. There was no argument on this, neither perhaps it was not brought to the notice of the Honorable Court. The judgment speaks no word about directive principles of the Constitution, which specifically deals with how the natural resources are to be dealt with it. The preamble of the Constitution also clearly says, and it is a unique character, which speaks that you should have a strong center. Though the heading of constitutional philosophy was given, the relevant judgments were not cited, and I have the compilation I will furnish to all our members. The entire reading of the judgment makes it as if the land and minerals are similar and same category, because according to the judgment, minerals forms in the land comprising of minerals. So according to me, as I submitted in the beginning itself, minerals are geological process formed in the earth. It is totally different and distinct from land. They can form anywhere in any fashion. So these two dissimilars made as equals in the judgment. Start from 1957, Subbarao J, we have the judgment saying that treating dissimilars as similars is arbitrary and offends the Article 14. Not only treating equals as inequals, even treating dissimilars as similars is also arbitrary. This aspect was also lost sight of it. And there is another principle which is recognized by the Supreme Court is doctrine of stare decisis. When once there is a judgment, passed decades together, and it is in vogue, the unsettling of the judgment is going to have such ramification on the society. It needs to be considered whether that unsettling comes under the vice of doctrine of stare decisis. That was also not considered. And there is another principle called nocitur dictum or ecetum generis. The words land and buildings was used. When once prefix is land, the suffix called building should have the common meaning or common color. And land I treat for the purposes of this act, subsoil rights are the earth as minerals, and buildings are separated. According to me, once the land and buildings are used, they are conjunctive, inseparable, coupled, and you can't have different yardsticks for building and different yardsticks for land. It is the word called and was used, not the or. And anything relatable to land, if one wants to tax or pass a legislation, there is an independent entry called entry 18 in list 2 dealing with the land in and above. Leaving that entry, coming to this entry called land and buildings, according to me is incorrect. And once you read the declaration made in MMDR Act, read with section 2 and read with section 5, 9, 9A, 13, 25 and 30, makes it very clear the entire field of minerals is occupied by the Parliament. Not only the payment of royalty, not only the payment of grant, not only the transportation of the minerals, every aspect is occupied if you read combinedly. One more important factor is MMRD Act does not grant or contemplate grant of any lease for the land. Section 5 says no mining lease shall be granted unless the occurrence of the mineral is proved. It is only the mineral bearing lands you will get the mining lease. So it is not that you will get a lease like now the one way it is said that Transfer of Property Act section 105, 106 is applicable to it. I am afraid because 105, 106 is relating to the lands, leases, etc. Whereas the leases under MMDR Act are of a special nature. There is a scientific proposition behind it. You can't get a mining lease for a barren land. Firstly, there should be a prospecting license or prospecting the area, and there is a report with the by the Indian Bureau of Mines that there exists mineral. Once there is a firm report, you call it as DP or whatever it is, firm report that this particular area contains a particular mineral, only for that particular area mining lease will be granted. Here the term called land is totally misnomer. It is totally misnomer. You will not get mining lease for land. You will get mining lease for an area which is otherwise proved that the area contains the minerals. So, bringing entry 49.2 to MMDR Act, according to me, is incorrect. Another important aspect of this judgment is several paragraphs of the judgment deals with the Mineral Concession Rules 1960. The Mineral Concession Rules 1960. It is a fact that the Mineral Concession Rules 1960 were repealed. They were repealed by Minerals Other than Atomic and Hydrocarbons Energy Minerals Concession Rules 2016. These new rules have come into force from 4th March 2016. Rule 55 of this new rules makes it very clear that Mineral Concession Rules 1960 are repealed. Once those rules are repealed, any judgment basing on such repealed rules requires to be revisited. And when we go by para, para 123, the majority view says the marginal note to section 9 has an importance to understand section 9. The legal importance of marginal notes of particular enactments are debatable. There are one line of decisions which says marginal notes doesn't form part of the statute and it has no binding nature. There are one line of decisions which says they are key to the understanding. But according to me, while doing this kind of judgments and relying upon marginal notes may not be so correct. And the judgment says in para 123, the liability to pay royalty arises of contractual condition. Because the majority view is mining lease is also like a contract. One should not lose sight of section 5 of MMDR Act, which contemplates order of grant of mining lease. It is the order of grant of mining lease under section 5 which imposes obligations on the lessee to follow rest of it. As a sequel, after section 5 order, if the area is in forest, section 2 clearance will come. If the area is in revenue, NOC from the collectorate will come. Thereafter a formal lease deed is executed. That lease deed may contain the conditions. It is not that the obligation of the lessee has arisen under the lease deed. The obligation arises under section 5 grant. In the absence of, it is only the grant from which these documents flows. That is how the mining leases are called as statutory leases. It is not that mining lease, you and I will have our own loving letters between us. The mining lease format is approved, written in the mineral concession rules, approved by the parliament. There is a statutory format. No state government can change even comma full stop. It is a printed format under which it used to be written. In any case, that form case gone now. There is no contract. Now, after 2015 amendment, it is only the sale of concessions. There is a new set of documentation, new set of rules. They were not considered, and this judgment is basing on Form K, which is no more in the IF law. In any event, the obligation of the lessee to pay royalty doesn't arise not under the contract, but under the order of grant itself. And paras 124 and 221, it is stated, it was held that uniform royalty stipulated by the central government is to ensure uniform mineral prices both in domestic and international market. The bench says uniform prices were contemplated by the Parliament under 57 Act, Section 9, for the purposes of uniform price, both domestic and international market. According to me, the uniform pricing policy has come because of Article 39, because of directive principles. And secondly, because of uniting 500 princely states. In these states, some princely states are rich in minerals, some princely states are rich in forest, some princely states are rich in water, some princely states are rich in valuable minerals, some are in normal minerals. How to balance it? And the industry, you can't set up a steel plant where there is no water but there is an iron ore. You can't set up a steel plant where there is a water but there is no iron ore. How do you balance it? It is totally a scientific thing. Why these public sector steel plants, or there are 6-7 public sector steel plants across the country? Why? In different places. There is a reason behind it. And spreading the socio-economic development across the country, industries are planned. And industries are planned, and it's not that the state which has the mineral, it can take complete advantage of it. There are captive leases. There is so much of science and logic and thesis, antithesis and brain behind the policies have come out for the past 70 long years. And the constitution makers have applied their mind and how it will happen. All these things you will find in the debates. You take Jharkhand today, which is the richest state in the minerals. Their exploitation is less, but if you see the mineral value, Jharkhand is the state which has the highest value of minerals. If you take Orissa, where the India's country's production is on one side and Orissa production is on the other side. So if you see the forest, there is a zero forest in some states, there is 27% forest cover in some other states. So one equilibrium has to be maintained. For that purpose, the uniform policy of pricing has come, not that any state should take undue advantage of whatever a particular mineral they have at their state. It is not that to have market conditions. And it is also intended indirectly because of the political reasons not to exploit the other part of the country. Para 125, they say that Section 9 does not make compulsory extraction of public authority. According to the majority view, that mining lease rentals or the royalty, if you don't pay, there is no compulsory extraction by a public authority. That is incorrect. If you do not pay the royalty, firstly one should know how this royalty operates. There are directorates of mines and geology in each state. They issue permit to each lessee to extract the mineral of so and so thousands of tons. When they issue permit, they calculate the royalty and they collect the royalty, and then only the permit will be issued. So the collection of royalty is not because of the contract and not by the somebody else will come and collect it like your cycle stand person. It is collected by none other than the Office of Director Mines and Geology, which is a public authority. It is only the public authority that imposes the royalty, collects the royalty. This aspect was also not brought to the notice of the Honorable Court. And the collected royalty, where it will go? It will not go to the somebody's kitty. It will go to the state's consolidated fund, Article 283. The royalty will go to state's consolidated fund under Article 283 too, so that it will be used for the public purpose. Similarly, Para 136, mine is generally defined as an excavation of earth for the purpose of obtaining the minerals. Once it is an excavation of earth for the purpose of obtaining the minerals, the concept of land is no more coexist with this. Para 182, it was held that tax has got 4 elements. Element 1, nature of tax. Every element, whatever they said in Para 182, the royalty satisfies. I have given in my write-up, royalty satisfies all 4 elements. Therefore, according to me, royalty is tax. And Keshavanand Bharati was quoted. Keshavanand Bharati said there are limitations which are implied of necessity and scheme of the constitution. So the limitations, as I stated at the beginning, there are implied limitations and the necessity and the scheme of the constitution is to be remembered. Majority of opined the Section 9 does not serve any limitation in taxing the statute. No, it is incorrect. Section 9 is not independent. Section 9 is to be read along with Schedule 2. Schedule 2 of MMDR Act is to be read as part and parts, integral part and parcel of Section 9. If you read both together, it is the section which contemplates the stipulation of the royalty of each mineral at what stage. Majority opined that government is to fund the public sector undertakings such as Mineral Exploration Corporation, etc. Mineral Exploration Corporation doesn't do any mining operations. Unfortunate that it was not brought to their notice. Mineral Exploration Corporation is a corporation established by the Parliament for a limited purpose of exploring the minerals which are untapped in an area. They just go into different areas, collect the samples and say whether this particular area has any mineral or not. They do not undertake any mining operations. They don't produce any mineral whatsoever. So that is also incorrect information, which is an input guided them to do this. The general sense land means all kinds of lands. Expression the land synonyms that I have already explained. The para 277, the observations in paragraph that is, I also said that classification. Majority of the land, I said the sine qua non for the mineral concession is there must be an existence of mineral. Para 280 says minerals and ores are part of earth. as per the majority opinion, it means hill deposits, embedded deposits were all formed because of the volcanic action of the earth, and thus minerals are found under the water as well as over the earth. Whereas 289 and 290 they say the nexus and applicability of 49.2 are not matching with the rational and erroneous, because there, if you want to impose a tax, there should be some nexus. Land and buildings is the entry. Minerals are not part of it, but you want to tax the mineral bearing lands. So there is no nexus according to me. That is how this judgment according to me requires to be revisited, and there are serious consequences because of the judgment. I also written the consequences. India has abundance of resources, metallic and non-metallic minerals. India has sufficient reserves in so and all minerals it has, and the rich mineral states are also there, Jharkhand and Orissa. And another important aspect is the difference between the ore and minerals. Both are used loosely. The difference between ore and minerals is this. The minerals which are capable of mined with a profit is called as ore. Everything in this universe is a mineral, but there are minerals which are capable of mined for a profit. There are so many minerals till yesterday, before the advent of the technology, they continue to be the minerals. Now they have become ores. So the minerals which are capable of mined for a profit, they will become ores. Every ore has its own different feature. If you see iron ore hillock, whatever water drops on the hill, it will comes down. Same hillock, if it contains bauxite, whatever water is there through rain drops on it, it will not come down. Bauxite will take like a sponge the water into it. That is why the hills, bauxite hills are always green. In summer it oozes out. In rainy season it takes the water into it. In summer it oozes out. That is how you will find any hill in the summer is green, means there is a possibility of bauxite being there. So similarly, there are each mineral has its own tendency and its own use. At one point of time, mica was called as the great mineral. People used to go to Rangoon and export mica, all those things. Now it has become an obsolete mineral. Nobody uses mica because the clay has taken place. Similarly, minerals, they are treasures. They are to be exploited at an appropriate time when the market is there. Otherwise, they will not get turned into ores. They will continue to be the minerals. So the conservation of the minerals is a big science and a policy decision behind it. There are mineral policies at the highest level of this country. And these policies are made by taking the inputs from the experts of this field. And the government of India makes the policies which is binding on all the states. Now the present judgment, as it stands today, when it confers powers upon the state legislature, because all along state legislatures are denuded from making any legislative enactments pertaining to the minerals, regulation, development, taxing on it. Now with this judgment, if this liberty is given to the states, the possibility due to the political reasons or whatever may be the reasons, the one rich mineral state may behave. We have seen one day this country has banned export of iron ore to China. I do not want to name the time. We have banned export of iron ore to China. Then China banned import of coking coal to India. Then 5 steel plants of this country were about to be shut down because of no coking coal. Then we had to discuss with China and restore the supplies. So there are so many issues, so many bilateral contracts with China, Japan and other countries. And for the purpose of socio-economic development, these minerals plays a lot of role. And because Ambedkar himself said in Constituent Assembly debates, the honorable courts can modify, but they cannot replace. They cannot substitute. They cannot say, I have quoted in my written brief, in 25th November 1949, Constituent Assembly debates, Ambedkar clearly says that the courts can modify or interpret, but they cannot add or replace the entries in the list. So therefore, keeping the constitutional philosophy, constitutional scheme, keeping the provisions of the MMDR Act, keeping the provisions of other parliamentary legislations, I am in agreement with the dissent view, and according to me the majority is required to be revisited. In the dissent view, it was categorically mentioned because I had an occasion to argue forest development tax, forest development fees before the Karnataka High Court, where Justice Subra Kamal Mukherjee was the Chief Justice and Justice Nagaratna was the sister judge. We have argued this matter about the interplay between all the entries, whatever is discussed now, and the supremacy of the central legislation. And the learned judge has passed about 500 pages judgment, Justice Nagaratna, relating to forest development tax. All these things were argued there. She has the advantage of knowing this constitutional scheme and written the judgment. So, any doubts?
Thank you very much, Raghavacharyulu garu. The way you explained entire the judgment and analysis and other thing, minerals should worry about your presentation. It looks like yourself is a big mineral, a ghani. How much knowledge you have entire mineral. We are highly grateful the way you explained. Further, you all the way you came, and otherwise would have been zero knowledge going all these 400 pages judgment. Before giving vote of thanks by Ayush, let us give a standing ovation to Raghavacharyulu. I request Ayush will give a vote of thanks, please.
So, no duty is more urgent than the duty of returning thanks. So it is with this immense delight I am giving this opportunity to deliver the vote of thanks on behalf of the entire Friday group. Sir, this is our 227th meeting, and we are very grateful that you graced this occasion with such wonderful insights. What sticks with me through this course of lecture is, as you mentioned, that it's judicious to know past in order to know present. I can only say that it is your hindsight of 33 years that has given us this foresight today, which probably I was not getting even while reading this judgment. Secondly, sir, I loved the fact that how you connected the theory of implied powers to the analogy of Neptune and Pluto. I wish I had teachers like that in my college. So I think it sticks with me quite a lot, and I'll moreover, moving on, sir, I would like to give a big thank to Mr. G.Seshagiri Rao, sir, our beloved administrator of the Friday group, whose Friday group lectures enabled me to develop an interest in philosophy of laws. So I'll ever be grateful for Sheshu, sir, so that the lectures are uploaded on YouTube. Moreover, I convey my thanks to every member of the Friday group as well as attendees herein who have given their valuable time towards this lecture. As the great philosopher Chiddi Krishnamurti said, we only learn when we listen with silence. So I'm grateful to all of you for your kind patience, and again very grateful to Sir, Sheshu sir, everyone on my behalf. Thank you, sir.
We are highly grateful to Mrs. Raghavacharyulu also. She is here. She too came all the way. Thank you very much, madam. So nice of you.
I would like to have any questions.
Only signature. Next one, message. Signature. For any questions?